I know they checked in. I was on mute. You were mute. I couldn't hear. I took it.
All right, I'm looking for Capital One Bank versus Ebony Williams, please.
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of plaintiff Capital One Bank.
Thank you. This is case number 22-177276. Thank you, counsel. Good morning to you. Do I have Ebony Williams present on this matter? All right, this is looks like the defendant's motion for the plaintiff's motion for summary disposition regarding the counterclaim in this matter. Counsel?
Thank you, Your Honor. First, in review of the ROA, I am not sure that the defendant actually filed that with the court, but given that she filed a 22-page document that indicated it included a counter complaint, we felt we needed to address it and filed our motion for summary disposition. A review of those 22 pages has two factual allegations. One, that we did not attach a signed agreement to the complaint, and one that I, not my client, but I am not licensed as a collection agency in the state of Michigan. I go through each of the accounts set forth and why they failed to state a claim. With respect to the two factual allegations, neither one of them give rise to a claim, in that under Michigan law, the use of the card would be equate to a signature of the credit card. And as I identify, I am exempt from registration under the statute she identified, as I'm an attorney. As such, we're requesting, to the extent that there is a counter complaint, that it be dismissed.
Once again, I'm looking for Ebony G. Williams. If you're on the Zoom, please say something at this time. Given that the defendant has not appeared, and given that the facts that or the allegations raised by the counterclaim would not seem to be supported by any factual and or legal scenario, I will grant the motion for summary disposition at this time, and will sign an order indicating that the counterclaim is in fact dismissed regarding this matter. So ordered.
Very good. Thank you, Your Honor. I'll submit that under 7 days.
Thank you, counsel. Counsel, regarding the underlying case, I don't know why the defendant has not appeared in this matter, but you have a complaint that you've raised, and I know that a default was previously entered in this matter. Are you asking for entry of judgment on your complaint?
We would request that the court enter the default judgment on our complaint against the defendant for her failure to answer.
All right. In review of the file and defendant having not appeared regarding this matter, the court having sent a notice to the defendant on the 20th of May of 2022, ordering that defendant appear on this date, August 1st. Defendant having not appeared at this matter set for 9:30, it's now 10:20. The court will enter the judgment by default at this time on the terms as prayed. The judgment will enter for $6,196.48 as so ordered.
Good. Thank you, Your Honor.
Thank you, counsel.
Have a good day.
Likewise to you, sir. The court now calls case number 22-182-530. This is Prism Lab LLC versus City of Detroit. I should say Prism Lab versus Prism Lab and Joint and Spine Specialist versus City of Detroit. The matter is before the court settled for a hearing on today's date. Your appearance for the plaintiff, if you will. Prism Lab, please. For the City of Detroit.
Good morning, Your Honor. Ben Patterson on behalf of City of Detroit, P85118. And I think the reason why plaintiff's counsel is not here is that we've actually done a stipulation of dismissal. of this case. Plaintiff agreed to drop it, and we filed the stipulation of dismissal with requesting order on July 20th. So I think counsel may have assumed that the court had already dismissed it, but I checked the register of actions and saw that it hadn't been entered yet. So I thought I should appear.
All right, thank you, counsel. And I appreciate that update. We will note the file that a proposed order of dismissal is being submitted to the court and will be signed upon receipt. So ordered. Thank you, counsel.
Thank you, Your Honor.
The court now calls case number 21-160-918. This is William Buford and Alice Tillman versus Allstate Insurance Company. The matter is set on for, for review. All right, your appearance for Buford and Tillman, please.
Good morning, Your Honor. Doug Harriskevich, P81458 on behalf of the plaintiff.
Thank you, counsel. Good morning to you. For Allstate Insurance Company, please.
Good morning, Your Honor. Reno Airboat for Allstate Insurance.
All right, your P number, if you will, for the record, sir.
P83692.
All right, thank you, and good morning to you as well. Somebody go ahead and update me regarding this matter.
Yes, Your Honor. So previously, we indicated to the court that there's a probate matter regarding the guardianship of Mr. Buford, and there was a question as who was going to be the guardian moving forward. There was a petition that was filed to terminate the existing one and reappoint a new guardian, and that happened on July, I believe, 14th. And I just saw the orders today, and the new guardian is a Miss. Sorry, I think it's Destiny Tompkins. And I do have her contact information. I left a message with her this morning. And I spoke with Mr. Arabo via the chat function today, and we agreed to simply enter a stip order, amending the caption so we can move forward properly with the proper guardian.
All right, is that correct, counsel?
Yes, that's correct, Your Honor.
All right. All right, the court will allow for the amendment of the caption based upon the stipulation so that this matter might advance now that the parties are framed properly in this matter. I know that there was an order, motion to compel discovery or something that I issued previously. So where are you with discovery now? What's needed yet in case to properly position this matter?
Well, now, Your Honor, we'll just depose Ms. Tompkins, and then after that, we should have everything we need, Your Honor.
Very well. So what I will do is I will allow discovery to remain open over the next 45 days, and then post that period, I will set the matter on for a pretrial, a final pretrial conference. So I'm going to give you a date. That's your final pretrial conference date. Discovery will remain open through that date. And that date is going to be
September 5th. Oh, I'm sorry, October 5th. I'm sorry, October. Yeah, October.
Yes.
I forgot it was August.
Is that 45 days now?
It's a little longer, but you cannot hear on that 1 week.
That's it.
You want to go to the 20 days of August? I mean, September?
Yeah. 9/28/22, and that's going to be at 9:45 a.m. September 28, 22 at 9:45 a.m. And we'll have a final pretrial conference at that time.
All right. Thank you very much, Your Honor.
Thank you, Your Honor. Thanks, Doug.
I'll send you that step.
Get that order into me so that we can make sure the file is reflected properly.
All right, we will.
Thank you. The board now calls case number 21-173-778. This is Credit Acceptance Corporation versus Demetra Crosby. The matters before the court set on for a hearing on today's date. Looks like this is a first hearing regarding regarding this matter. Your appearance for credit acceptance, please.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Your P number, if you will, for the record, Ms. Olivier.
39006.
All right, thank you, and good morning to you, Madam Counsel. I'm looking for Demetra Crosby at this time. If you're on the Zoom, please say something at this time.
Good morning, I'm here.
All right, thank you, Mr. Crosby, and good morning to you as well, sir. I see that you did submit an answer regarding this matter. You indicated that you had moved, and this was the first time receiving papers. And you also indicate a couple of ways you're not sure what it means. This case is about an indebtedness that is claimed regarding a purchase of a motor vehicle, it appears, and that vehicle was purchased along with Brittany Banks, and the purchase date appears to have been sometime in 2018, May 30th, 2018, and the plaintiff is seeking to recover the deficiency balance with regard to that case. And that deficiency balance is in the nature of $12,000 plus interest that is accrued on that in the nature of $2,900. All right, that's the nature of the claim that's brought, that's being brought in this matter. All right, Mr. Crosby, did you in fact purchase a vehicle or sign off on the purchase of a vehicle?
Yes, I was in a relationship at the time, and we had I had co-signed. Well, we went together and got the vehicle.
All right, and I take it that perhaps when you broke up, you left the vehicle with her or something like that. Is that what happened?
Yes, unfortunately, she didn't continue to pay it. So I'm just here to really just to deal with it, get it over with.
All right. Yeah, it's one of those tough kind of situations because of the fact of the co-signing thing, you know. We almost need to eliminate the language called co-signing, but I guess it's the best language we have because when you sign for somebody else, it's like you are totally equally responsible for the indebtedness, and that's what has happened in this situation. What I'm going to do is I'm going to take a moment, Ms. Olivia and Mr. Crosby, and put you in a breakout room and see if you can kind of talk through what this would look like in terms of some type of resolution.
Your Honor, we have already been in a breakout room and we have resolved the matter.
Oh, okay. All right. Well, tell me about that. Well, whatever you guys did, you were on the right track. As pretty or as ugly as it may seem, you're on the right track. That's kind of the best way to go about looking at what you do in the case. Go ahead, Madam Counsel. Tell me what's going on.
Okay, the parties agreed to the entry of a consent judgment for plaintiff and against defendant for the full amount as paid for in plaintiff's complaint, which is damages of $15,102.20, costs of $265.33, $75 statutory attorney fee for a total judgment amount of $15,442.53. The parties agreed to allow the defendant to pay that judgment in installments of $200 per month beginning August 17th of 2022. And the defendant will be paying $200 on the 17th of each month thereafter until the judgment is paid in full. I will be emailing him a consent judgment to sign and return. So once he does that, we will also sign it and forward it to the court for entry.
All right, Mr. Crosby, is that the agreement that you have reached to resolve this matter, and ultimately with partial payments being made on the judgment, sir?
Yes.
All right, that would in fact resolve the case. I would also indicate, although it's not a part of any agreement, that certainly if you get in a position where you're able to come up with some type of lump sum, you may want to call into the office to credit acceptance and see if they'll accept something as a lump sum payout. But in the meantime, the agreement will call for the $200 a month payment on the judgment until it is satisfied. All right, I will sign an order upon its presentment to the court. And Ms. Olivia, you may email that. I'm going to give you the email address where you can send it. That is Latifa. That's LATIFAH, Latifa.Hunter@36districtcourt.org.
And we will do that once we receive the signed consent judgment back from the defendant.
All right. And let me ask you, Mr. Mr. Crosby, if the defendant initials the judgment based upon the terms that you've reached, as the plaintiff initials the judgment based upon the terms that you've reached in this document on this record, would it be acceptable to send it to the court if it says what you've agreed to?
Yes.
All right. So you can send it to the court. I mean, so long as it says exactly what's been placed on the record will reflect that Mr. Crosby is in agreement, and you would indicate his initials and agreed upon on the record in open court, and submit the judgment.
Okay, so I'll sign both our names and say with permission for his name. Got it.
Yeah, and then email it to the court, and Mr. Crosby will make sure that you get a copy of the order as it will say exactly what's agreed.
Okay.
All right. All right. Good day to both of you. Wish you well, and talk to you soon.
All right.
You as well.
This is case number 22-182752. This is Silverlink Resources LLC versus City of Detroit Auto. The matter is before the court, looks like, for a scheduling / status conference. For the plaintiff, Silverlink, your appearance at this time, please.
Good morning, Your Honor. Joey Atuma, P80627, on behalf of the plaintiff.
All right, thank you, counsel. Good morning to you, sir. For the City of Detroit, Michigan Auto, that's a little bit different, but your appearance at this time, counsel.
Good morning, Your Honor. Patrick Cunningham for the City of Detroit. My P number is 67643.
All right, thank you, Mr. Cunningham. And I see in the city's response that you left off the Michigan Auto. I don't know what. So let's see what the original summons had Michigan Auto, City of Detroit, Michigan Auto. I don't know what that's about. All right, so what's the, have you talked about this at all? What discoveries needed? Is this something that you can come together on fairly quickly, or tell me where you are? Have you talked about it at all?
No, Your Honor, I don't believe we've engaged in any discovery yet. We have not received anything from the defendant at this time. We just filed our witness list, and that's about it so far.
All right, so what I'm going to do is set this up on a 60-day discovery order, and the return date that we're going to give you in just a moment. The discovery will be open through that date. You'll get a written order from me with certain information, and we'll have that date and the next hearing date. That date's going to be October 5th. October 5th will be the next action date on this matter. Discovery will be open through October 5th. That's going to be at 9:30 a.m. Will be the hearing. I would also indicate that on the paragraph number 6 of the order that's going to be sent out by the court, it does give you the opportunity to set motions for hearing on that date as well. And that those motions, if you wish to dispositive or otherwise, you may bring a motion and set it for hearing on October the 5th, so long as you provide at least 10 days notice to the opposing party. So notwithstanding the typical court rules regarding motions for summary disposition and other items, if you have an issue that you wish the court to rule upon on the 5th, you may very well bring that motion as long as you give the other side at least 10 days to respond to the same. So it is a motion hearing date if you wish for it to be that. If that does not become a motion hearing, that does not preclude you from filing motions in the future. It's just that if you, in the process of discovery, if there's any motion that you wish to bring and you feel that you have something that's positive, you can certainly bring it and set it for hearing on the 5th of October. So you'll get an order from me. That will be the next action date, and that will be the cutoff of discovery. All right, I wish you well, gentlemen, and you'll get the order in the mail in the next few days. Good day to you.
Thank you, Your Honor.
Thank you, Judge.
All right, this is case number 22242503. This is Nafisha Hassan versus Universal Auto Tech. On the matter is set on for a hearing on a small claims appeal. The time set on this matter is 9:45 a.m. I'm looking for Hassan and I'm looking for Universal Auto Tech. Does not appear that either party has appeared in this matter. Accordingly, the decision of the magistrate in this matter will stand. The claim of appeal will be dismissed at this time.